We have major legal developments tonight, and they look like this, and I'm going to walk you right through them. These are two separate cases where two judges have ruled for major Epstein transparency and basically changed what is longstanding precedent on what materials you release from criminal probes. I'm going to walk you through it here in plain English. The big development today is one of these cases, a judge granting a motion to release sensitive Epstein records, specifically to unseal what are grand jury records in the Ghislaine Maxwell case. Now that mirrors another ruling, and I'll tell you about that as well. But if this sounds like a huge change, it is. If you think back to every case you've ever looked into, maybe you're a true crime Whitey Bulger fan, maybe you remember the Mueller probe, grand jury materials are protected by Rule 6, which is one of those sort of long-standing rules of the federal court system. And the reason the grand jury materials are usually secret is because, unlike, say, an open trial where the government is presenting certain evidence, this is a private process designed to decide whether you get to trial or not. And for many reasons of fairness, say they don't indict and move forward.
Okay, so let me just start by telling you about the two-front battle Trump faces right now, because in court, judges have held him in contempt and openly warned that jail is on the table while in Congress. Detailed impeachment papers brand him unfit to govern and build the case for his removal. Judge Mon found Trump in contempt for repeatedly violating gag orders and stated he is prepared to impose jail time if fines don't work. Meanwhile, HS 353 charges Trump with 7 articles of impeachment, calling him a threat to the Constitution. The pressure is building from both the judicial and legislative branches simultaneously.
Donald Trump has found this was an issue he could not spin or outrun, and his base remains interested in whether he complies with this law, which they know he was forced to sign. And Congresswoman MTG, who sparred with Trump over this and other issues, ultimately resigning, made some pretty interesting new remarks about the Epstein back and forth with Trump in her 60 Minutes.
We did talk about the Epstein files, and he was extremely angry at me that I had signed the discharge petition. He said that it was going to hurt people. I had asked him, these women are the ones that were hurt.
He said to you, people will get hurt.
People will get hurt. I don't know what that means. I don't know who they are.
Because understanding both the courtroom pressure and the impeachment papers matters for evaluating the multiple tracks of accountability Trump faces. So here's what's happening on the court front and why the jail warnings are serious. In Trump's Manhattan hush money case, Judge Juan Miran found him in contempt for repeatedly violating a gag order. The order barred attacks on witnesses, prosecutors, court staff, and their families. Trump violated it multiple times through social media posts targeting people involved in proceedings against him. Mann imposed $9,000 in fines for 9 violations and ordered Trump to delete the offending posts. The escalation from fines to jail warnings came when Merchian acknowledged that monetary penalties weren't achieving compliance. He stated in open court that if fines don't work, he is prepared to impose jail time. His exact words captured the tension. As much as I would like to avoid jail, I will do so if necessary and appropriate. The statement acknowledged reluctance while asserting willingness to use available enforcement tools. The gag order violations weren't trivial or ambiguous. Trump attacked witnesses scheduled to testify against him. He targeted court staff and their families. Each attack created potential safety concerns for the people involved and risked prejudicing proceedings. The violations were deliberate. Trump knew the restrictions existed and chose to ignore them. The contempt findings documented willful defiance rather than inadvertent error. The impeachment papers represent the legislative track of accountability pressure. HRE's 353, introduced in the current Congress, is a comprehensive 7-article impeachment resolution. This isn't a symbolic protest document. It's formal constitutional accusation laying out specific charges and seeking Trump's removal from office. The 7 articles cover substantial constitutional ground. Article 1 addresses obstruction of justice and violation of due process. Article 2 addresses usurpation of Congress's appropriations power, spending money without congressional authorization, or withholding funds Congress appropriated. Article 3 addresses abuse of trade powers and international aggression. Article 4 addresses violation of First Amendment rights. Article 5 addresses creation of an unlawful office. Article 6 addresses bribery and corruption. Article 7 addresses tyranny as summary accusation encompassing the pattern of abuse. The resolution's language about Trump's fitness for office is explicit and damning. It states Trump has demonstrated that he is unfit to govern. It declares he has acted in a manner grossly incompatible with self-governance and the rule of law. It warns he will remain a threat to the Constitution if allowed to remain in office. These conclusions aren't hedged criticisms. There are formal constitutional determinations calling for removal. The resolution has been filed as a privileged measure which matters for procedural reasons. Privileged status means the sponsor can force House leaders to deal with it on the floor rather than letting it die quietly in committee. This prevents the resolution from simply being buried. It requires an affirmative vote to table or reject it, putting members on record about whether they support advancing impeachment. The December 2025 vote on Representative Al Green's separate impeachment articles demonstrated substantial support already exists. Green's resolution focused on abuse of power and incitement of violence, including allegations about calls for executing Democratic lawmakers. 140 House members voted to advance those articles before the Republican majority tabled the resolution. That's more than a third of the House willing to advance impeachment over party line opposition. The connection between courtroom conduct and impeachment allegations creates reinforcing narratives. The same behavior that produces contempt findings in court, public attacks on judges, court staff, and witnesses also appears in impeachment texts as evidence of tyranny and efforts to destroy and corrupt the legal system. Trump's courtroom defiance becomes exhibit in the congressional case for removal. The impeachment papers explicitly cite his contempt for court orders as a reason he's unfit to remain president. The documents describe a wide-ranging scheme to destroy and corrupt the legal system and the powers of the courts. The courtroom behavior isn't just a legal problem, it's a constitutional problem, demonstrating unfitness for office. Each contempt finding strengthens the impeachment case, even as it creates separate judicial consequences. Trump's own acknowledgement of the impeachment threat confirms he takes it seriously. He told House Republicans that if they lose the midterms, they will surely find a reason to impeach me. I'll be impeached. He's explicitly tying his survival in office to maintaining Republican majorities. He recognizes the impeachment papers are loaded and waiting for political opportunity. Let's break down exactly what the contempt findings established, what the impeachment articles allege, and why the two tracks of pressure reinforce each other. Alright, so to really understand the two-front pressure Trump faces, we need to examine the courtroom contempt proceedings and the impeachment papers separately, then see how they connect to create reinforcing accountability pressure. The picture shows a president facing judicial enforcement threats and detailed constitutional accusations simultaneously. Let's start with the courtroom contempt because it involves the more immediate enforcement mechanisms. Judge Mahan's gag order in the hush money case prohibited Trump from publicly commenting about witnesses, prosecutors, court staff, and their families. The restrictions served legitimate purposes, protecting trial integrity by preventing a defendant with massive platform from targeting people involved in proceedings against him. Trump's violations were documented and deliberate. Each contempt finding identified specific statements that crossed the lines the order drew. Truth Social posts attacking witnesses scheduled to testify, comments targeting court staff and their families. The violations weren't ambiguous or inadvertent. Trump knew the restrictions existed and chose to ignore them. The pattern showed defiance rather than misunderstanding. The $9,000 in fines for 9 violations represented maximum available monetary penalty. Merchan imposed what he could through fines while reserving more serious sanctions. The escalation pattern followed standard judicial practice: warnings, then fines, then consideration of custody when lesser measures prove inadequate. Mahan's acknowledgement that fines weren't achieving compliance marked transition to jail warnings. His statement about being prepared to impose jail time if necessary and appropriate put Trump on notice that incarceration was available. The reluctance he expressed, as much as I would like to avoid jail, acknowledged the unprecedented nature of jailing a former president, but willingness to proceed despite reluctance demonstrated judicial resolve to enforce orders. The contempt proceedings document Trump's approach to legal constraints. He treats orders as suggestions to be ignored when they conflict with his preferences. He continues prohibited behavior despite knowing restrictions exist. He persists after consequences are imposed. The pattern visible in the hush money case appeared in other proceedings too. Courts across multiple cases have found Trump unwilling or unable to comply with standard legal requirements. The impeachment papers represent a different track of accountability operating through constitutional rather than judicial mechanisms. HS 353 is formal impeachment resolution laying out 7 articles of high crimes and misdemeanors. The document follows the constitutional template for removal proceedings. Article 1 addresses obstruction of justice and violation of due process. The allegations connect to Trump's pattern of interfering with investigations, defying oversight, and attacking judicial proceedings. His treatment of the Justice Department, demands for prosecuting political opponents, and responses to cases against him inform this article's accusations. Article 2 addresses usurpation of Congress's appropriations power. The Constitution gives Congress the power of the purse, authority to decide how government money is spent. The article alleges Trump violated this by spending money Congress didn't authorize or withholding funds Congress did appropriate. Executive actions that bypass congressional budget authority raise constitutional concerns. This article captures. Article 3 addresses abuse of trade powers and international aggression. Tariff policies, threats against allies, and use of economic leverage for political purposes fall within this article's scope. The allegations position Trump's conduct toward other countries as exceeding constitutional limits on executive authority. Article 4 addresses violation of First Amendment rights. Attacks on press freedom, retaliation against critics, using government power to suppress speech, Trump's pattern of threatening media, and treating criticism as enemy activity informs these accusations. Article 5 addresses creation of an unlawful office. Questions about the legal authorization for certain administration entities fall within this article. If offices lack statutory basis but exercise government power, that raises constitutional concerns about executive overreach. Article 6 addresses bribery and corruption, connections between official actions and personal benefit, conflicts of interest, and questions about using the presidency for self-enrichment inform this article's accusations. Article 7 addresses tyranny as summary accusation. This invokes founding-era concerns about executive abuse and positions Trump's overall pattern of conduct as exactly what constitutional structure was designed to prevent. The resolution's conclusions are explicit and unqualified, unfit to govern, acted incompatibly with self-governance and rule of law, will remain a threat if allowed to remain in office. These aren't hedged criticisms. They're formal constitutional determinations calling for removal. The document exists and waits for political opportunity to advance. The privilege status of the resolution matters procedurally. Privilege measures can be brought to the floor over leadership objection. The sponsor can force votes rather than letting leadership bury the resolution in committee. This means the impeachment question must be confronted rather than ignored. Members must vote on record about whether to advance or table the articles. The December 2025 vote on Representative Greene's separate articles demonstrated substantial support for impeachment. 140 members voted to advance articles accusing Trump of abuse of power and incitement of violence. The Republican majority tabled the resolution, killing it procedurally, but 140 votes against table-abling shows more than a third of House membership willing to advance impeachment despite party-line opposition. The connection between courtroom conduct and impeachment allegations creates mutual reinforcement. The impeachment papers cite Trump's wide-ranging scheme to destroy and corrupt the legal system as evidence of unfitness. The contempt findings in court document specific instances of that scheme in action. Each contempt finding provides exhibit supporting the impeachment narrative. Trump's attacks on judges, court staff, and witnesses aren't just gag order violations. They're evidence of the tyranny article's accusations. The impeachment texts describe efforts to destroy courts' powers and corrupt legal proceedings. The contempt findings document exactly that conduct in specific cases. The courtroom behavior proves the constitutional accusations. The two-front pressure creates a situation where Trump faces accountability mechanisms in both branches simultaneously. Courts can impose contempt sanctions up to and including jail. Congress can pursue impeachment and removal. Neither branch controls the other's proceedings. Both advance based on their own processes and timelines. Trump must defend on multiple fronts with different procedures and standards. Alright, so let's bring this all together and talk about what the two-front pressure actually means and why the combination of courtroom contempt and impeachment papers creates compounding accountability threat. The key insight is that judicial enforcement and constitutional removal mechanisms operate simultaneously, with each track reinforcing the other. The contempt findings document Trump's willful defiance of court orders, 9 violations, $9,000 in fines, explicit warning that jail is available if fines don't achieve compliance. M's statement about being prepared to impose incarceration put Trump on notice that his status as former president wouldn't protect him from custody. The judicial track creates immediate enforcement pressure. The impeachment papers lay out comprehensive constitutional case for removal. 7 articles covering obstruction, usurpation of congressional power, abuse of authority, constitutional violations, corruption, and tyranny. The unfit to govern language calls explicitly for removal. The resolution exists in formal congressional record, waiting for political opportunity to advance.